Speedy trial, habeas corpus, and the cost of delay. Justice moves slowly. Sometimes that is a virtue. A careful investigation protects the innocent. A thorough review protects the integrity of the verdict. A rushed trial can produce wrongful convictions. But justice can also move too slowly. Evidence grows stale. Witnesses disappear. Memories fade. Employment is lost. Families fracture. A defendant who entered the system presumed innocent may spend months, or even years, living under the weight of unresolved accusations. The Constitution anticipated this danger. That is why it guarantees something remarkable: the right to a speedy trial. It also preserves one of the oldest protections in Anglo-American law, the writ of habeas corpus. Together, these protections exist for a simple reason: government should not be allowed to imprison people indefinitely while deciding what to do with them. Why speed matters. The Sixth Amendment guarantees criminal defendants the right to a speedy and public trial. The wording is simple. The application is not. What counts as speedy? 30 days? 6 months? 2 years? The Constitution deliberately avoided a fixed number. Instead, courts examine the circumstances of each case. The reason is obvious. A simple misdemeanor and a multi-state murder conspiracy are not the same thing. A shoplifting accusation and a complex financial fraud investigation do not require the same amount of preparation. Context matters. Still, delay has consequences. Those consequences often fall most heavily on the accused. The punishment before conviction. A defendant awaiting trial may experience loss of employment, housing instability, family separation, mental health deterioration, medical interruptions, financial collapse. A defendant held in jail experiences all of those risks at once. Even defendants released on bond often live in uncertainty. Employers ask questions. Licenses may be suspended. Professional reputations suffer. Savings disappear. The legal system may describe the individual as awaiting adjudication. The family often experiences something closer to punishment. The Federal Speedy Trial Act. Congress attempted to give practical meaning to the constitutional guarantee through the Speedy Trial Act of 1974. The law established deadlines for major stages of federal criminal cases. Generally speaking, federal prosecutors must file charges within 30 days of arrest, and federal trials ordinarily must begin within 70 days after indictment, or the defendant's first appearance in court, subject to numerous exclusions and exceptions. The exclusions matter. Complex cases may justify additional time. Pretrial motions pause the clock. Competency evaluations pause the clock. Continuances requested by defense attorneys may pause the clock. The law seeks balance rather than speed alone. The constitutional test. The United States Supreme Court addressed the constitutional right to a speedy trial in Barker v. Wingo. Rather than adopting a strict deadline, the court created a balancing test. Judges generally consider 4 factors. 1. The length of the delay. 2. The reason for the delay. 3. Whether the defendant asserted the right. 4. Whether the defendant suffered prejudice because of the delay. No single factor automatically controls the outcome. The analysis is highly fact-specific. That flexibility allows courts to account for complexity. It also creates uncertainty. Georgia's speedy trial statutes. Georgia provides both constitutional and statutory speedy trial protections. Under Georgia law, defendants may file formal speedy trial demands under specific statutory procedures. If those procedures are properly followed and the government fails to try the case within the required terms of court while juries are available, dismissal and acquittal may result. The process is technical. Deadlines matter. Court terms matter. The wording of the filing matters. The location of the filing matters. Many defendants hear the phrase speedy trial and assume it operates automatically. It generally does not. Like many constitutional rights, it often must be asserted to become effective. Hall County as a local lens, Hall County criminal cases proceed through the same pressures affecting courts throughout America. Judges manage crowded dockets. Public defenders carry heavy caseloads. Prosecutors handle hundreds of files. Laboratory evidence may take months to return. Witnesses relocate. Experts become unavailable. Continuances occur. Most delays arise not from bad faith, but from limited resources and growing workloads. Yet even unavoidable delays have human costs. A case delayed for administrative reasons feels no less real to the family waiting for resolution. The calendar looks different from inside a jail cell than it does from behind a courtroom bench. The pandemic lesson. The COVID-19 pandemic exposed the fragility of the criminal justice timetable. Jury trials stopped in many jurisdictions. Courtrooms closed. Backlogs expanded dramatically. Cases that might once have reached trial within months waited years instead. The pandemic was an extraordinary event. It revealed an ordinary truth: the system depends upon continuous motion. When that motion stops, consequences accumulate quickly. Across the country, courts continue working through residual backlogs years later. Witnesses and memory delay affects more than defendants. Victims suffer too. Witness memories fade over time. Details become uncertain. Addresses change. People move away. Some die before trial occurs. The passage of time can weaken both prosecution and defense cases. This is one reason the right to a speedy trial belongs not only to defendants, but also serves the broader public interest. Justice delayed can become justice denied for everyone involved. Habeas corpus. Produce the body. Long before the United States existed, English courts developed a simple but powerful idea. If the government imprisons a person, the government must explain why. The mechanism became known as habeas corpus, Latin for, "You shall have the body." The court orders the government to bring the prisoner before a judge and justify the detention. The principle is ancient. The importance remains modern. Without habeas corpus, detention risks becoming arbitrary. With it, government authority remains subject to judicial review. The United States Constitution protects habeas corpus so strongly that suspension is permitted only under extraordinary circumstances such as rebellion or invasion. The founders viewed it as one of liberty's essential safeguards. Habeas corpus in practice. Modern habeas corpus petitions take many forms. A prisoner may challenge unlawful detention, constitutional violations, jurisdictional defects, ineffective assistance of counsel, improper sentencing. Federal habeas review has become increasingly complex over the decades, particularly following legislative reforms designed to limit repetitive appeals and provide greater finality to convictions. Critics argue restrictions sometimes prevent legitimate claims from receiving review. Supporters argue endless litigation undermines confidence in verdicts and burdens courts. As with many criminal justice debates, both concerns have merit. The emotional cost of waiting. The legal system measures delay in months. Human beings measure delay differently. 1 missed Christmas, 2 birthdays, 3 school graduations, a marriage under strain, a child learning to live without a parent at home. The defendant may eventually be acquitted. Time does not return. The economics of delay is expensive. The defendant pays with lost income. Families pay with depleted savings. Taxpayers pay for jail operations. Counties pay for detention costs. Businesses pay through employee turnover. Communities pay through instability. Justice delayed carries invoices that rarely appear in court records. Why courts sometimes move slowly. Judges do not usually delay cases for entertainment. Prosecutors do not generally seek postponements for convenience. Defense attorneys do not routinely request continuances without reason. Complexity drives much of modern delay. Digital evidence may involve terabytes of information. DNA testing may take months. Financial crimes may require forensic accounting. Expert witnesses may have limited availability. The justice system became more accurate over time. Accuracy often requires time. The challenge is knowing when delay serves truth and when delay simply serves inertia. The difference between preparation and stagnation. There is an important distinction between preparation and stagnation. Preparation protects fairness. Stagnation erodes confidence. Preparation allows evidence to emerge. Stagnation causes evidence to disappear. Preparation respects due process. Stagnation undermines it. The constitutional challenge is balancing these competing realities honestly. The right that must be used. Many defendants assume constitutional rights activate automatically. In practice, many rights require action. The right to remain silent must be exercised. The right to counsel must be requested in some contexts. The right to a speedy trial often must be asserted. The law frequently protects those who know how to invoke it. This creates another inequality. Knowledge itself becomes a resource. Those with experienced counsel often navigate the process differently than those without it. The clock and the Constitution. The founders understood something simple. Power becomes dangerous when it can detain without explanation and delay without consequence. The right to a speedy trial limits delay. Habeas corpus limits detention. Together, they form a constitutional clock that continues ticking even after the jail door closes. That clock protects the guilty from arbitrary government. It protects the innocent from disappearing into procedure. And perhaps most importantly, it reminds government that liberty is not something it owns. Liberty belongs to the citizen. Government merely holds it in trust. The next chapter follows the money again: fines, court costs, supervision fees, and the growing concern that modern criminal justice sometimes functions less like punishment and more like debt collection. Global Robotics Corporation, Robert Colee,